All right,
Give
thank
this to
you.
probation or the clerk here?
Oh, just give it to probation.
Yeah.
All right, are you already on Mackie? All right, we're back on the record in 2014 CR 59, I'm sorry, 2014 CR 5495 State versus Joshua Mackey. If I could have parties re-announce, please.
Defendant for the state of Texas. And Kelly Fiddle for Joshua Mackey.
All right, and this is a continuation of the hearing that was started this morning. State, any witnesses?
Fortunately, it's not having markers.
All right, defense, any witnesses?
That's right, Judge.
All right, the court has found violation of condition number 5 true. The court is going to find violation of condition number 1 not true. The court is going to find 15 FF not true. All right, any objection to the court's reviewing the court summary?
None from the state. Can I see it?
And for the record, the court has not reviewed the court summary.
Can I remove the violation reports?
You'll have to speak with probation about it because that's their
Sure.
court summary.
I just don't, I have no problem with you speaking to the court summary, but not the violation reports since they're not. Okay, that's right. No objection, Judge. Oh,
so
you have your own? Sorry.
No, I don't.
Oh, okay, then, yeah, that's,
Yes.
All right, so what portion are you all asking me not to read?
I didn't realize that the violation reports are already in the court's file that you,
Yes.
that's taken judicial notice of, so no objection, Judge.
Okay.
And if we could just have time for a brief argument after.
Yes. Oh, and counsel, I don't have a trial court certification.
We'll get you one, Judge.
Okay. Oh, do you want to grab that while I read this?
Sure.
And state defense and Mr. Mackey, I see that there's a condition of number 1 in here. I previously said that that condition is not true.
Yes, Your Honor.
So I'm not going to consider that because I found it not true. And it's the same dimension of condition 15 FF. I've also found that not true.
Thank you, Judge. Judge, can I present to the court?
Yes.
I'll have it marked if you would name it to. The state has waived this condition 10D, but I just wanted to bring it to the court's attention that the restitution is paid in full.
So was the restitution 36,000 or was it 44,775?
It was, what he owed was the 4,000 number.
Okay.
The total was the 36. The 4,000 was paid.
All right, the court has reviewed the court summary and the court has reviewed the document that the defense asked the court to review. State, what are you requesting?
Your Honor, you've taken judicial notice of the entire court file. You're aware of the facts of this case, the egregious nature of them, involving shooting the victim through the head, the right temple, exiting out the left side of her face. Very well could have killed her. Thank God it didn't. Otherwise, we'd be here on a different charge. So given the facts of the case, given that the defendant is on his second MTR since he had been placed on probation, And given the one true violation you found, Your Honor, they would ask for him to be revoked, adjudicated guilty, and sentenced to 10 years TDC.
All right, just one moment. I'm just trying to find in the court's file, I'm trying to find the admonishments page. Were you all able to see that, the admonishments page?
I don't recall, Judge.
If you could, and everyone, just one moment. Yes, thank you. All right, so as a part of your plea bargaining agreement that was entered into, the state was silent on your application. So I'll note that for the record.
Yes, Judge.
All right, defense, the state is asking for revocation and they're asking that your client be sentenced to 10 years in the prison. What are
Judge-
you requesting?
Judge, we're asking that you deny the MTR and terminate his probation. In regards to the facts of the original case, I believe I represented him at the time of his plea, and the complainant was okay with him getting probation. Judge Hilbig gave him probation, gave him jail time as a condition. In between when Mr. Mackey committed his offense and when he pled, Mr. Mackey was shot in the head and almost died. That affected his brain functioning. He had a TBI and went through competency and was competent to stand trial. In regards to this being a second MTR, the state waived the first MTR, so it's not really something that the court, we believe, should consider. And we asked the court to reconsider that true finding. And the reason we asked that, Judge, is if you review those conditions of probation that are in the court's file, I've never had a contested MTR in which the state didn't either have the probation officer who read him those conditions testify that he signed those conditions, or number two, have someone, a fingerprint examiner, come in and testify that that thumbprint matches Mr. Mackey's thumbprint. The state has failed to prove that Mr. Mackey signed those conditions of probation, that he had knowledge of those conditions of probation, and therefore nothing could be found true because they haven't proved that he is the person who signed these conditions. In addition, what I testified to earlier and what Ms. Fuentes testified to was that there was no testimony or evidence presented by the state that Mr. Mackey knew to report to probation. There's nothing in those conditions that say, if this case gets transferred back to Bexar County, you must report to Bexar County probation. All it says is condition number 5 is report as directed to Bexar County. Well, we know that wasn't an actual condition of Mr. Mackey because he lived in Harris County. He was reporting to Harris County this entire time. Now, if the court still finds that it's true that he violated condition number 5, the court can do so, and we respect that. But we ask the court to review the totality of the case and that they have proven that he failed to report for 1 month out of 120 months. That's 0.8% of the time that they allege that he failed to report. And we ask that you consider what they've alleged and what they've proven and deny the MTR and release Mr. Mackey from this probation.
All right, the court is, as previously stated, the court is finding 5 true, 1 not true, 15 FF not true. The court will find the defendant guilty, grant the motion, revoke. There's an affirmative finding of deadly weapon. And I don't.
The admonishments may be in the second picture, but I can find it in this file.
Oh, the clerk printed it out. I couldn't find it either. I'm trying to see because I'm not the one who did the plea. The previous. I have the plea bargain, but there are no mention of no contact or, I'm sorry, there are no mentions of any no contact orders. So
I have,
I'm sorry, Counsel, do you have the trial court certification?
I haven't had him sign it yet, Judge. I need to explain to him.
want to see.
Yes, please. Okay. All right, there should be no contact. There's to be no residing in any households with minors. And the court will sentence you to 6 years in the prison. Give you credit for any time served. Is there anything else?
We asked for findings in fact and conclusions of law.
And have you gone over the trial court certification?
I have not, because
All right, if you'll go,
he needs time to understand it.
yes, okay. And then just come back and I'll finish.
And that's how quickly years of second chances can come to an end. Joshua Mackey's story was one of near-death, recovery, and hope. But in the end, the weight of his past caught up with him. The court listened, the defense pleaded, and Judge Boyd made his decision. 6 years behind bars, a moment of silence, another life rewritten by choices that couldn't be undone. In that courtroom, justice didn't shout. It whispered. Because sometimes the harshest verdict isn't the sentence, it's realizing the chance you had is finally gone.
All right, who else is ready?
We're ready to sit down. It's
Michael
Michael Sewell.
Sewell?
So since I discovered I have curly hair, I have taken an interest in curl pattern
See, let me
and
just tell you,
products.
we are saving Bashan, right?
Well, it sounds too late. Well, not her aunt though. The products make all the difference for me.
It does, it does. And you know, people who have curly hair don't want curly hair, people with
Mhm.
straight hair want curly hair.
Yes,
I just decided in my time on the planet, let it do.
let it do. Yes, I understand that.
All right, the court is calling 2025 CR 00732 State versus Michael David Sewell. Can I have parties announced?
Lauren Espinosa for the state.
Lauren left in for Mr. Sewell.
And are you Mr. Sewell?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
We did, Your Honor.
The court will find that the state is in compliance with discovery. All right. And is there any applications?
No applications.
All right. Mr. Sewell, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are we proceeding on the indictment as presented?
No, Your Honor, if you would allow, the state would move to orally amend the indictment. It is alleged as the defendant's name is David Michael Sewell, but I believe his proper order is Michael David.
Any objection?
No objections to that. That's correct.
Mr. Sewell?
Yes, ma'am.
All right. We also need to, how do you spell your last name?
SEWELL.
All right.
So we may need it. for-
Then also, Your Honor, may we add another after the W in the last name?
No objections.
All right. Any objection to the court changing the name in the paperwork?
No, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yeah. Yeah,
Yes,
yeah.
yes?
Yeah.
Well, yes, ma'am, yes, ma'am.
Okay,
I was thinking, I thought I went no to continue.
She hasn't asked you.
Okay, oh,
did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
yes,
Did you understand by entering this plea, you're giving up those rights?
yes,
And did you intend to do that and enter into a plea in this case?
yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Sewell, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No,
Are you satisfied with where you've been represented?
yes, ma'am.
Are you a U.S. citizen?
Yes,
Oh, I'm so sorry. I'm not supposed to ask you whether or not you're a citizen. Did you understand by entering into this plea, if the court follows your agreement, if you are not a U.S. citizen, you will be deported, denied naturalization, and re-entry into the United States? Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes, ma'am.
According to the plea, punishment is to be assessed at 60 days in the Bear County Jail under 1244, and there's $1,000 fine. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, debating such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
Yes, Your Honor. State offer states exhibit 1 in all attachments.
No objections, Your
All
Honor.
right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing the same, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just asked the court follow the plea agreement.
All right. So the court will find you guilty. The court will sentence you to 60 days in the Bear County Jail under 1244. There's $1,000 fine, time and money will run concurrently. And the court will give you credit for any time served. Is there anything else with regards to sentencing?
No, Your Honor.
I'll question your $1,000 fine. How long was that?
The money and fine run together.
Okay.
All right. Did
All right.
you have questions or not?
No, I'm okay.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
Did you understand it and sign it?
yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
yes,
All right, we can go off the record. Here's the thing. It's obvious that you have a drug problem, right? If you do not solve that problem, 1 or 2 things are going to end up happening. First thing, you're going to continue to get arrested, and you're going to end up spending a majority of your life in jail or either in prison. Or number 2, you're going to end up getting a hold of some bad drugs, or who knows, maybe the drugs are just fine. But that one time, there may be some issues. And the last time you use may be the last time you use, and then somebody's going to have to identify your body. Do you understand?
yes,
Now, when you're released from the Bear County Jail, if you cannot find a place that can help you with sober living or help you with any drug issues you may have, If I'm still here, you come back here and I'll pick up the phone and call somebody to help you. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you.
May we be excused?
Yes.
Thank you. Nice seeing
Have a good
you.
one.
Johnson,
Who's next?
Sergio Martinez, page 6.
Sometimes justice isn't just about punishment, it's about a warning, a last chance. Michael Sewell walked in facing 60 days behind bars for a small amount of drugs, but what he got was something far heavier: the truth. The judge didn't raise his voice. He raised a mirror. If you don't change, one day someone will be called to identify your body. In that moment, the courtroom fell silent, because everyone knew he was right. Justice isn't always cold. Sometimes it's a final lifeline, wrapped inside a sentence.
Court is calling 2023 CR 3770 State versus Donna Lynn Ellis. Can I have parties announced?
Flores notes for the state.
Peter Calderola standing in for Gail Calderola from Miss Ellis, Your Honor.
All right, do you have any objection to this attorney standing in?
No, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Ellis, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with evading arrest, detention with a vehicle. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do so believe, Judge.
Do you believe she is currently competent and was legally sane at the time of the offense?
Yes, Your Honor, I believe she was.
Ms. Ellis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and denied re-entry into the United States. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's an $800 fine. There are no applications. The state will take in consideration CC 701359. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
None that I'm aware of, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offers states exhibit 1 in all attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. What is happening with the drug?
I believe which case, Judge?
Well, in the police report, they say that she had drugs.
That was rejected, Your Honor, back on 5/2 of 2023 when our office received notice.
Right. All right, is there anything else you wish to say on behalf of your client?
Yes, Judge. I understand that my client, I believe, has 128 days credit here in Bear County. However, she's been in custody since the inception of this case. She was sentenced to TDC out of a different county, and that sentence occurred, I believe, in December of 2023. So my client has roughly about a year and 10 months of time at TDC. So we're asking the court, respectfully requesting the court satisfy this judgment today.
All right, then she'll receive, well, I'm not going to judgment satisfied, but what I will tell you is you'll receive custody for any time that you've been in custody while this case has been pending. All right, so if you were in custody and this case was still pending, I'll give you credit for that.
Okay.
All right. So do you know which TDC case number that is?
I do not have the TDC case number. My client does have that information in her jail cell.
So what we can do is just, your counsel will call the court and he'll let us know which case number it is, and I'll have it run concurrently with that, and you'll receive credit for that.
Yes, ma'am.
All right.
Thank you.
All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, normally, Miss Ellis, I will recommend the therapeutic community for people who want it, but it appeared in the police report that you said you did not want to stop using. So do you want me to recommend the therapeutic community for you? It doesn't increase the time that you're in custody, but it's to help you with any other issues you may be experiencing.
While I was in TDC, I completed a 120-day MTC program, drug rehabilitation
Okay,
program.
that is awesome.
Also anger management, and I got extra college credits. I was also a teaching assistant for GED to my other peers.
Mhm.
I completed a Christian 12-step program. So I wasn't just sitting there idly by.
All right, so has that been helping you?
It has.
All right, so this is what I'm going to tell you, what I've noticed, and I don't want you to fall into this trap. Usually when people get out of prison, they celebrate and it goes downhill from there. So when you're released from prison, if you cannot find a sober living house or someplace to help you, if I'm still here, you come back here, I'll pick up the phone and call somebody to help you.
Yes, ma'am. I
All
do
right.
have a place to go.
Oh, that is so awesome. All right, well, good luck to you.
Thank you very much.
All right, thank you.
Thank you, Your Honor. May we be excused?
Yes.
And I will be in touch with the court to provide that TDCJ number.
All right, thank you. Oh, yes, we are going to stop at noon.
Like today?
Either today or I'll set the jail visit for tomorrow, okay?
Thank you.
Counsel, did you get your dismissal from the state to take to the other court?
I do have a judge.
All right, thank you. Anyone else ready?
Yes, page 42 down.
All right, Eric Mason. All right, Mr. Mason, Wayne Mason.
Mr. Mason? The box.
Come down, sir. Hi, Mr. Mason. All right, so your attorney is out ill. I don't know when your attorney is going to be available. So it may be best, yes,
Yeah, we're expecting it back within the month, to be honest.
what, this month? So you have a choice. You can either continue with this attorney, but what I can tell you, if your attorney is still out and unavailable, there's going to have to be a new attorney appointed because these cases have been around for a while. Do you understand? So here's my question. Do you want this case reset? It'll be reset later this month, and that attorney will have to appear, or would you like another attorney appointed to represent you? It's completely up to you.
I believe the max is somewhere to function notice.
Yes.
If that,
But it would also have to be said.
No, I mean, we'll get you an attorney here today.
Okay.
So what would you prefer?
After bidding.
All right, just have a seat. We'll make sure you have an attorney today. All right, thank you.
Thank you very much, Your Honor. May I excuse?
Yes. Or would you like another?
And
attorney
sometimes
appointed to
justice
represent
isn't
you?
about punishment, it's about perspective.
It's
Donna Ellis
completely up
faced
to you.
years behind bars for evading arrest, but what stood out wasn't her crime, it was her comeback. From addiction to rehabilitation, from anger to teaching others, she fought her way back toward hope. The judge saw
No,
that
I mean,
spark
we'll get you
and
an
instead of
attorney here
judgment,
today.
offered guidance. When you get out, find a
So what
sober
would you
path,
prefer?
and if you can't, come back. We'll help you. In that moment, the courtroom wasn't
All right,
cold.
just have a seat.
It
We'll
was
make sure you
human.
have an attorney today.
Because sometimes the hardest
thank
verdict
you.
to
Thank you very
deliver
much, Your Honor.
is
May I
believing
excuse?
someone
Yes.
can still change,